Does the US government have the right to regulate or infringe on our Second Amendment rights? A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. What's up, guys? Ryan here with Carey University. I hope you're enjoying as we dive deep into the Second Amendment and exactly what it means so that you can protect and understand your rights. So does the government have a right to regulate or infringe on our Second Amendment rights? This is a topic where many gun owners begin to disagree. Some claim that all firearms laws are in direct violation of the US Constitution and therefore invalid, while others believe that the Second Amendment, just like all amendments, is not unlimited. Like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever or for whatever purpose. For example, concealed weapons prohibitions have been upheld under the amendment and state analogs. The court's opinion should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools, government buildings, or laws imposing conditions and qualifications on the commercial sale of firearms. Miller's holding that the sorts of weapons protected are those in common use at the time finds support in the historical tradition of prohibiting the carrying of dangerous and unusual weapons. U.S. Supreme Court, Heller v. D.C., page number 27. It's important that you really notice the term that was used there, which is common use at the time. This is the exact reason why AR-15s are protected under the Second Amendment. This is also the reason why the National Firearms Act was passed in 1934. To regulate unusual and so-called dangerous weapons that are not in common use at the time, such as machine guns, short-barrel rifles, short-barrel shotguns, silencers, and destructive devices. There seems to us no doubt, based on both text and history, that the Second Amendment conferred an individual right to keep and bear arms. Of course, the right was not unlimited, just as the First Amendment's right to free speech was not. Thus, we do not read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation, just as we do not read the First Amendment to protect the rights of citizens to speak for any purpose. U.S. Supreme Court, Heller v. D.C., page 22. Like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone throughout the 19th century, cases, commentators, and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever or for whatever purpose. For example, the majority of the 19th century courts to consider the question held that prohibitions on carrying concealed weapons were lawful under the Second Amendment, or state analogs. Although we do not undertake an exhaustive historical analysis today of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. We also recognize another important limitation on the right to keep and carry arms. Miller said, and we have explained, that the sorts of weapons protected were those in common use at the time. We think that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. U.S. Supreme Court, Heller v. D.C., page 54 and 55. The problem that I have with this is the Second Amendment is the only amendment that actually uses the term shall not be infringed. So what did the Founding Fathers really mean by that term shall not be infringed? According to the U.S. Supreme Court, D.C. versus Heller, page 40, shall not be infringed means curtailed or broken in upon in the smallest degree. You're contradicting yourself, Supreme Court. Like, if it shall not be infringed means shall not be curtailed, broken in upon in the smallest degree, then that means we shouldn't have to have a concealed carry permit to carry a gun concealed. We shouldn't have to go apply for a permit to buy a gun in some of these anti-American states like Illinois, New York, and New Jersey. Dictionary.com defines infringed as to commit a breach or infraction of, violate, or transgress, to encroach or trespass. If the Founding Fathers truly believed that our God-given right to own and possess firearms should not be curtailed or even restricted, even to the smallest degree, then why are states like New York, California, New Jersey, Illinois, Massachusetts, Connecticut allowed to impose strict firearms regulations on law-abiding citizens? In the next video, we're going to talk about the 3 reasons why the Second Amendment was created. This is fascinating stuff. It's going to blow your mind, so make sure you stay tuned. Share the video, subscribe, give it a thumbs up, and I'll see you next week. Stay safe.